9-year-old walked out of the house first and he wasn't hurt. Nobody who lived in that house had done anything at all. The man who wouldn't come out had picked the address at random. He'd never met them. The house held together for another 19 hours. Then it didn't. 11 years later, the man who owned that house signs his name to a case belonging to strangers. He gets nothing from it. Prime documentary. 2 doors. Behind one, the government has to pay you. Behind the other, it doesn't. Nobody gets to choose which door the emergency comes through. Greenwood Village, Colorado, a suburb south of Denver, where the lawns are edged and the streets curve for no reason. A 2-story house on South Alton Street. Leo and Alfonsia Lech had bought it for their son John, and that June, John was living there with his girlfriend and her 9-year-old boy. Nothing about that morning belonged to them. Somewhere north in Aurora, officers had tried to arrest a man named Robert Seacat. He ran. He was armed. He broke into the house on South Alton Street. It wasn't his house. He had no connection to the family who lived there. When Greenwood Village police arrived, they learned there was a man inside and that there was a child inside. The 9-year-old got out. The record puts it plainly and without drama. He was able to exit the home safely. The boy was out. The gunman was not. Then a shot came from the garage and hit a police car, and the situation acquired a name. High-risk barricade. For about 5 hours, negotiators tried to talk him out. They failed. What came after is written down in a federal court record, in flat institutional language, which is the only language anyone uses for this kind of thing. The court's account of the night runs a few sentences. This is all of it. Officers fired several rounds of gas munition into the house. An armored vehicle called a BearCat breached the home's doors so a robot could carry in a throw phone. Explosives were used to open sight lines and points of entry. Holes to see through, holes to move through. A tactical team went in. Seacat fired on them. They pulled back. Then the BearCat came again, and this time it punched multiple holes in the house, and the team went in through those, and it ended. 19 hours. By then, the officers had been given an instruction, recorded by the federal district court and quoted ever since. Take as much of the building as needed without making the roof fall in. The roof did not fall in. Nobody in this story did the wrong thing that day. The tactics weren't challenged. What Leo Lech would spend the next years arguing about was never whether the police should have destroyed the house. It was who pays for a house destroyed for the public's benefit. The city offered help with temporary living expenses. $5,000. That figure appears in the family's own petition to the Supreme Court, described in those words as help with temporary living expenses. 6 years later, in a brief filed by his lawyers, Lech added something the appeals court's record doesn't contain. He says the $5,000 came with a condition that he give up his right to sue. That's his account, and it should be heard as his account. What the 10th Circuit's own document says is narrower and, in its way, colder. The city offered assistance with temporary lodging, denied any further responsibility, and refused additional compensation. So he turned to the thing everyone turns to. He had homeowners coverage. He'd paid for it for years, for exactly this, for the day something enormous happens to your house. When the policy was read, it excluded intentional acts by government officials. Coverage exists for a fire. No policy covers the state deciding to come through a wall. He was paid for part of it. The rest was his. Then came the walls themselves. Breaking open a house built in that era released what was inside them. Asbestos. According to his brief, the dust was through the structure, and he was walked into the rubble to pull out what was left of his family's belongings without being told what he was breathing. What was left to salvage fit in his hands. Somewhere in that pile was a 9-year-old's room, and the boy who had walked out of it at the start of all this never came back to it. To rebuild, he borrowed $250,000. He had been planning to retire. He pushed it back 5 years. 5 years of a man's life moved because a stranger he'd never met chose that door. And no one in this had done anything wrong. The city broke no law, and every officer performed the job the way the job is supposed to be performed. The entire cost of all that correctness landed on one family who had contributed nothing whatsoever to the emergency except an address. He sued. Of course he sued. He believed what most people believe, that the Constitution has a sentence for exactly this. It does. Nor shall private property be taken for public use without just compensation. 14 words at the end of the Fifth Amendment, and he thought 14 words would be enough. They were not. In January 2018, a federal district court in Colorado ruled against him, and its reasoning had two moves. When the state acts under its police power rather than its power of eminent domain, its actions do not constitute a taking, and these officers were destroying the house in order to enforce the criminal law. Police power, not eminent domain. That was the ruling. Nothing owed. Eminent domain is the state deciding it wants land for a highway or a reservoir. It takes and it pays. Police power is the state responding to a danger. It stops, it seizes, it destroys, and under the line the court drew, it doesn't pay. The same house, the same rubble. By the time a judge in Denver wrote that distinction down, the house on South Alton Street had been gone for more than 2 years. Lech appealed. On October 29, 2019, the 10th Circuit affirmed, a panel of judges Holmes, McKay, and Moritz, with Judge Nancy Moritz writing. The document is not an opinion. It's an order and judgment, and this is its own first-page footnote. The panel didn't pretend the outcome was comfortable. It conceded that the police here acted for the benefit of the public. It reached back to an 1887 case, Mugler v. Kansas, for the principle. And then it borrowed a line from another federal appeals decision. As unfair as it may seem, the court wrote, the takings clause does not entitle all aggrieved owners to recompense. Lech argued the obvious thing, that he was innocent and that innocence should count. The court answered that this position has considerable appeal as a matter of policy. Considerable appeal. And then it quoted the rule anyway. The innocence of the property owner does not factor into the determination. The court was careful to say the police power isn't unlimited. Due process constrains it, and under Colorado law, an officer who willfully or wantonly destroys property can be sued personally. Neither of those doors was open to a man whose house was destroyed correctly. He asked the Supreme Court to take the case. On June 29, 2020, it declined. A denial of review decides nothing. It just ends things. If this happened once, it would be a tragedy about one house. Indiana. June 2022. Police believed a murder suspect had used the internet address at Amy Hadley's house. They had a warrant, an IP address, and the wrong home. Amy Hadley's 15-year-old son was the only person in the house, and he surrendered. 30 canisters of tear gas had already gone in through the broken windows. The suspect wasn't there. The damage came to about $16,000, and the city and the county each refused to pay it. In October 2025, the 7th Circuit rejected her claim. Texas, July 2020. A fugitive took a 15-year-old girl hostage inside a home belonging to a woman named Vicki Baker. Police fired dozens of gas canisters, blew the front and garage doors, and pushed down the backyard fence with an armored vehicle. When they entered, he had killed himself. Her insurer covered none of the police damage. A federal jury said she was owed nearly $60,000, and the 5th Circuit erased it, holding that when destroying property is objectively necessary during an ongoing emergency to prevent imminent harm to persons, the takings clause requires no compensation. Baker was eventually told she was owed it, but not by the federal Constitution. A court said so under the Constitution of the state of Texas. A different document in a different building saying a different thing. Tennessee, 2022. Deputies came for the Slaybaw's son, who was staying with them, and put about 35 gas canisters into the house. Roughly $70,000 of damage. In 2024, the 6th Circuit called a categorical police power exception questionable, then dismissed the claim anyway on an old common law privilege attached to searches and arrests. In November 2025, the 9th Circuit ruled that Carlos Pena gets nothing. 13 hours earlier, in August 2022, an armed fugitive had shoved Pena out of his own print shop in Los Angeles and locked the door behind him. SWAT put gas through the walls, the doors, and the roof. Nobody disputes the police acted lawfully. Then Nevada. August 2025, Las Vegas. A SWAT raid hit a home over a suspect who had lived at that address more than 5 years earlier. About $30,000 of damage. The department denied the claim and then, after the story ran, reversed itself and covered it. Same kind of emergency, same kind of damage, and the difference was not a rule. It was a news cycle. That's the argument Leo Lech's lawyers now make. Whether you are made whole is not decided by the Constitution. It's decided by which city you happen to live in. In November 2024, when the Supreme Court declined to hear Vicky Baker's case, Justice Sotomayor wrote a statement respecting that denial, joined by Justice Gorsuch. It carried no legal weight. It wasn't the court's opinion, and it wasn't a dissent. It was filed alongside the refusal itself. She wrote that the case raises an important question that divides the courts of appeals: whether the takings clause requires compensation when the government damages private property under its police power. She wrote that all agree the McKinney police acted properly that day. She mapped the split: the Seventh Circuit and the Federal Circuit on one side, the Sixth reaching the same result by another road, the Fourth Circuit holding that government action under the police power is not automatically exempt from the takings clause. She cited Lech by name, and she said the question would benefit from further percolation in the lower courts before the court steps in, adding that the denial expressed no view on the merits. There is one more filing. In May 2026, 11 years after his son's house was opened with explosives, and 6 years after the Supreme Court declined to hear him, Leo Lechs signed his name to a brief in someone else's case. 2 cases, actually. Hadley's and Pina's, both filed on April 6, 2026, both distributed for conference on September 28. Both still pending. 2 cases from 2 states, asking the question the 10th Circuit answered in a document it refused to call precedent. Nobody knows how they end, and anyone who tells you otherwise is guessing. He gets nothing from those cases. He isn't a party. His own claim was over in 2020. He wrote it anyway, alongside 2 strangers from Las Vegas whose house was raided over a man who had moved out 5 years before. Justice Sotomayor and the parties on every side of this quote the same sentence from a 1960 case called Armstrong. The takings clause was designed to bar government from forcing some people alone to bear public burdens, which in all fairness and justice should be borne by the public as a whole. Some people alone. Right now in most of this country, the answer is the address. Hadley and Pina go to conference on September 28th. Subscribe if you want to know what they're told. Next, the search that begins before you are a suspect.